Our speakers tonight will be Sonali Naik. Sonali is a distinguished junior barrister specialising in this field at Garden Court Chambers. I'm sorry, at 2 Garden Court.
No, Garden Court Chambers.
Garden Court Chambers, and is a former chair of the organisation.
Thanks very much for inviting me, JCWI. At least holding the seminar here made it possible for me to arrive on time. I didn't have far to come. I apologise if the room is a bit hot. I think that's just unfortunate in the way that when it's packed out, which I'm really pleased to see. I'm going to just talk briefly. I don't have a watch, so please do wave at me madly when the time is up, to talk about family migration and human rights in the context of Article 8 and the new government consultation. I know that Helena is going to be talking in detail about the terms of the consultation, and that Richard's going to be talking in particular about his case that JCWI brought, the Keeler case, which you will hear more and have heard some, no doubt, already. Anyone who has had even the slightest engagement with the human rights debate and policy over the last 11 years, since the Human Rights Act came into force, might be forgiven for thinking that somehow immigration was eclipsed from the scope of human rights provision. Because although Article 8, as we know it, protects the right to respect for private and family life, it obviously requires a balance against the requirements insofar as is necessary and lawful in a democratic society in the interests of national security, public safety and the economic well-being of the country, prevention of crime and disorder. These sound like old hat phrases, but it's really important when you look at the current debate on Article 8 to unpick the particular phrases in the Article 8.2 justification in order to look at how government policy is framed and where it's going. Because even though we know the terms of Article 8, the government, purportedly having regard to that balancing exercise in the last 10 years, has managed to propose or introduce arguments in respect of restrictions on the freedom of the right to marry, extension of the probationary period for spouses from 1 to 2 years, restriction on the rights of settled British people to sponsor their relatives relying on third parties, language testing for family migrants, including spouses, loss of family reunion rights for refugees who become British citizens, and as we will hear from Richard Dravel, in particular, age restrictions on spouses for people seeking entry or leave to remain. The list is endless, and those are just a couple of examples of issues that have concerned JCWI and other NGOs campaigning in this field over the last decade. So what we can learn from these examples and the trend in government policy as a whole is the continued and continuing restriction on migration for family members, purportedly justified with reference to Article 8.2, in the interests of national security, public safety and economic well-being. But that's usually referred to in shorthand as the importance of maintaining immigration control. But there's been very little consideration of the impact of the discriminatory aspects of immigration control against particular sections of society or particular migrant communities. And I challenge whether such a justification in respect of some or all of those restrictions that have been proposed is or was merited. And we know that some of the cases have been appealed, and I'll talk about that in a moment. But, for example, is it necessary, and in the interest of maintaining immigration control, to restrict the access to the UK to spouses of British citizens and those settled here on the basis of language skills? Can that be justified on the basis of economic well-being and wider policies about integration and so on, which is purportedly justified by the public good or the overall interests of society? Is it necessary, in the interests of maintaining immigration control, to restrict family reunion rights to refugees who become British citizens? Is that proportionate? Now, it's right to say that in no small part, due to JCWI, that several of those restrictions have been overturned in the courts. For example, in the House of Lords, the restriction on the right to marry in the Bai case, which Eric and Richard were involved in, which included the discriminatory operation of the Certificate of Approval scheme, which, apart from other things, excluded those who married in a Church of England church from the requirement to obtain a certificate, and in any event, the cost of obtaining those certificates was held to be prohibitive and discriminatory. But even then, long after that judgment of the House of Lords, the Home Office continued to operate that scheme, minus the fee requirement, admittedly, until its final abolition this year, with an acceptance then, very late in the day, that it didn't actually operate as an effective method by which to identify sham marriages, But then we now see in the new proposals something potentially far worse, and I'll leave the detail of that to Helena. But so what we have seen is that we have the rights under Article 8. We see the courts clamping down on the government's interpretation of those rights, and yet still the government does not implement those judgments, and then in the name of government policy and possibly to appease party conferences and so on, puts forward even more draconian proposals. The age discrimination case and the spouses in the case of Keeler, about which we hear more. But in relation to refugees denied family reunion as a result of subsequent citizenship, they succeeded in their case in the House of Lords. But the government's response to that success was to change the immigration rules, pretty shortly thereafter to tightly define refugee family reunion and to refer only to those who had current refugee status. In my view, that's simply not fair, it's not necessary, and it's not proportionate. And that's just an example of how the government has acted in the past and how we can't expect, in my view, anything positive that's going to come from this family consultation. It was published in July this year, and it follows on from those harsh proposals that have already been enacted with even more draconian suggestions. Now, the Home Secretary says, "We will aim to strike a proper balance between the individual's rights for respect for family life and the broader public interest." Now, the broader public interest is not a phrase that you find in Article 8.2, which is one of the reasons I read it out. It's just something that the government has come up with in terms of how they wish to define human rights and the rights to respect for family life. For example, she said it's obvious that British citizens that are settled here, and those settled here, should be able to marry or enter into a civil partnership with whomever they choose. Well, that's their view now, but that wasn't the view before by I, because they were obviously trying to restrict that right to marry quite considerably. But then she says, well, if they want to establish their family life in the UK rather than overseas, then their spouse or partner must have a genuine attachment to the UK, be able to speak English and integrate into our society, and they mustn't become a burden on the taxpayer. Families should be able to manage their own lives, and if a British citizen or settled person can't support their foreign spouse or partner, they can't expect the taxpayer to do it for them. Well, since when has the taxpayer been supporting foreign spouses? Absolutely, for decades. I've been practicing probably for almost 20 years, and the maintenance and accommodation rules were in place then, and I'm sure that Habib will tell us how long back they go, because of his long-standing involvement in immigration. There is no current expectation the taxpayer will support spouses or other family members. The rules are very tightly defined. It's a very misleading, divisive statement, and it shows that the government isn't leading the debate from an honest and true stance, because it's clearly slanted to appease or to address a certain section of the party and the party conference and the public Daily Mail reading, perhaps contingent. And furthermore, any suggestion that family members seeking to enter the UK should have to satisfy a greater burden in terms of access to maintenance and accommodation is wholly unjustified and unwarranted. There's no possible integration benefit that can be justified in respect of raising the income threshold for such people. The Home Secretary also says the government coalition has a firm commitment to human rights. Okay, so far so good. But then she says that there's been considerable public debate as to how these rights are to be interpreted, and particularly the interpretation of Article 8. And she says Article 8 allows for consideration of the public interest. Again, this phrase, the public interest, doesn't appear in Article 8.2, appears in the Home Secretary's speech, as well as the individual's rights to respect for family life. That's why we've established a commission to help investigate the creation of a UK Bill of Rights. Terrifying. I find that prospect terrifying. The only possible outcome of that commission is to restrict the rights of non-residents and non-nationals to be able to rely on human rights arguments and principles. And what she says is that it's my sincere hope that the Commission will help bring some common sense back to this admittedly difficult area. So what the message she's sending out is that the system is nonsensical. And you might feel it's difficult to take that commitment to human rights seriously from the Home Secretary, who allowed herself to be exposed to such blatant, crowd-pleasing nonsense in the story that became known as Catgate. Now, forgive me for... yes, I'm sorry. I am being a bit childish and a bit crowd-pleasing because I've even mentioned the Catgate story. But Catgate is important because it involved It wasn't, in fact, of course, a case that involved a criminal deportation. It was, misleadingly, quite often cited alongside cases of convicted criminals who challenged deportation on Article 8 grounds. But in fact, it concerned a man who came to the UK as a student, was refused leave to remain, and it did not concern, or not on the grounds of criminal convictions. The immigration judge allowed his appeal on the grounds that it would be disproportionate on Article 8 grounds to remove him. He had a long-term relationship with a person settled in the UK, and they'd lived together for 4 years. The reference to the cat was one detail amongst many provided by the couple as evidence of their genuine relationship and long-term relationship, and the judge ruled it wouldn't be reasonable to expect his partner to move to Bolivia with him, as the partner's father was seriously ill and he was helping take care of him. They also relied on other government policies, but the conclusion on appeal was that all the other factors in relation to the ownership of the cat and so on were immaterial, and it was the conclusion was that it would be unreasonable to expect the partner to relocate given his ties that he had in the UK and his caring responsibilities. But notwithstanding that, the Home Secretary was able to quite famously trumpet that story and purport that it was the cat that prevented the deportation. I think at this point, just briefly, and I hope I have time to do it, just to talk briefly about statistics, which the Home Secretary also has relied on, not in this particular document, I think, but more broadly, that according to the Daily Mail website, it says in 2010, 233 appeals against deportation were made and 149 were successful, which suggests a 64% success rate. But in fact, the figures were not correct. The figures actually are that there's only 149 out of 850 appeals on Article 8 in deportation context that were successful, a success rate of about 17%. And so, again, there's a distortion which the Secretary of State, the Home Secretary, does not seek to correct, and it's out in the public domain, and those figures are also propounded by Dominic Raab, the MP, who has a blog where he himself refers to examples of a drug offender was convicted of beating his girlfriend and he doesn't even pay maintenance for his daughter, and yet his appeal was allowed. This is on Dominic Raab's blog. But the facts of the case don't appear on the blog. The facts of the case were that the appellant had lived in the UK since he was 4, and that he had a child who he had a strong bond with, and the evidence was that he was a good and caring father. And the conclusion was that the impact on the family unit as a whole, that the deportation would be disproportionate. So we don't see any correction of these stories from the government. And so when we come back to her statement in the consultation, we want a system that's clear and consistent. We want a system that lets everyone know where they stand and makes clear what their responsibilities are. And we want a system that's fair, seen to be fair, to applicants and to the public. That may sound fair, but how can you ensure fairness to applicants and the public alike? The public aren't going to marry a foreign national citizen. The public aren't going to have to decide where's the best place for their children to live. The public aren't going to be unable to learn English and want to settle in a country that's free from strife and upheaval. So it's not an appropriate test to say that you have to balance the public interest in the same way, which is why Article 8.2 is drawn in the terms that it is, which doesn't refer to this bland and broad catch-all public interest, but more tightly defined provisions. As the JCWI notes in the briefing, the cumulative effects of the measures in the paper will be to create harder, longer and more precarious routes for securing entry and settlement to the UK for familial purposes. It will have a profound consequence on those involved in such relationships, and without there being significant evidence, the proposals will further the stated government objective of facilitating integration, reducing abuse of the system and protecting public services. So the measures are an erosion of international human rights standards and are likely to disproportionately impact on the right to family life, in particular for women and certain particular ethnic groups. Next year marks the 50th anniversary of the Commonwealth Immigrants Act, which saw the introduction of significant immigration restrictions from people around the Commonwealth. And the Act targeted mostly people coming from the Caribbean and South Asia and came at a time of significant racial tension in the UK. The current proposals on the restriction of family migration pander to those same populist and reactionary undercurrents, and to be as much feared as an indicator of things to come, and should be vehemently opposed.